constitutionalism, constitutional theory, and so he is a natural fit to have a conversation with us here today. Again, as Christine said, please just raise your hand if you have a question or send it to her in a chat and we can pose it to Professor Baude for you. But I'm going to take sort of moderator's privilege here and ask Professor Baude the first question to kick us off. And then he is, of course, welcome to speak for however long he'd like. But I think that a lot of people think that this is sort of a legal proceeding. We've heard a lot about how impeachment is much more of a political proceeding in reality, that it's not bounded by things like what is a high crime and misdemeanor. It doesn't have to be an actual criminal charge in some ways. But we've heard lots of conversations about the constitutionality of trying a former office holder. And I want to ask you what that conversation that we're having and what the fact that a majority of Republicans seems to think that it's not constitutional to try a former office holder, what does that do to future impeachment? If it is a political process, not truly a legal process, it doesn't create precedent in the same way that a legal precedent is set. But how do we interpret the judgment of nearly half of the Senate that this impeachment is unconstitutional in the next impeachment proceeding? And how do we reckon with the difference between politics and law and what senators are using law as a political tool here?
Yeah, no, these are great questions. So I'm going to break that into two questions. One is the nature of the proceeding, and the other is the late impeachment. So I think people don't always know this, especially, people don't always know this, but the courts are not the only parts of government that interpret the Constitution. So, most obviously on TV, President Biden took an oath to uphold and support the Constitution, but also every member of Congress and the House and Senate, when they take office, they're sworn in to support the Constitution. And it's the same oath that they take the same oath the judges take, the same core oath the judges take. The Constitution puts them in the same category. I think with the expectation that they have to worry just as much about whether they're allowed to do whatever they do as judges do. We now have gotten really accustomed to relying on judges. We think of them as sort of mostly interpreting the Constitution, but they're not the only ones. And members of Congress have a responsibility to do that. And then in an impeachment, they take another oath, right? So the very beginning of the impeachment trial, all of the senators get sworn in to sort of put on their special impeachment hats. I think, again, with the expectation that they'll be a little more focused on law and sort of neutral principles of what's good for the country, and not just the things they might do in their normal political day-to-day. So the structure is set up, the expectation, the senators are doubly sworn to think about the Constitution and justice and sort of neutral principles. Now, in practice, they don't always do that. I mean, we worry about partisan divisions on our courts, and I think we also have obviously partisan divisions in our legislature. And so in practice, we see a lot of these things break down more on partisan lines. But that ought to be something that concerns them a little bit. And I think we see at least some of them worrying about that and trying to take these things seriously. And it is on purpose that impeachments are given to the Senate and not to like the Supreme Court. When the framers wrote the Constitution, they thought about having impeachments tried in the Supreme Court. And they said, well, they're not quite appropriate for this job because it's partly about the Constitution, it's partly law, but there is obviously a political aspect to it. So the theory was the Senate would be the happy medium, able to sort of consider both high principles and politics. I worry they're not living up to that entirely, but that's the idea. So when they sit, right, they do consider constitutional questions, as we've seen. There are these briefs and constitutional arguments about how to read Article 1 of the Constitution and Article 2, and what was the original understanding of this textual phrases. And they even do worry about precedent in a way. Like in the House and Senate in general, there are these giant books of precedents when they have to consider things that, again, we often don't think about, like, what does budget reconciliation apply to, or what happens when there's a 50-50 split in the House and Senate? Who can, how do we split the committee chairs, or, how do we abolish the filibuster? All sorts of like procedural questions. It's not like a court. So they don't have judicial rulings and sort of the same principles of precedent as a court, but they do have precedents in a loose sense. They remember we did this last time. They have to think about, is this the same, is this different? So one of the things they all have talked about is that this idea of sort of an impeachment of somebody after they've left office has happened before. It happened in the 1880s during Ulysses S. Grant's administration. In a similar and different. It was not the president. It was his Secretary of War, William Belknap, who people thought was corrupt. And the House was beginning impeachment proceedings. Now, unlike President Trump, it's not that he just sort of like his term didn't just run out. He learned that the impeachment was coming and ran to Ulysses S. Grant that morning and asked him to please, accept his resignation. And Grant, being, I think, a little slow in the uptake, said, "Oh, sure, why not? Sorry to see you go." Only to learn that like an hour later, the House was beginning their impeachment vote. And so then suddenly the House said, "Well, wait a minute, can you do that? Can you run across the street and resign to avoid our trial?" And what we're seeing now is actually very similar to what happened then. So what happened then is it went to the Senate. The Senate had long legal arguments about this question, and I'm happy to talk about the merits if you want to, but long legal arguments about this question. Can you try somebody who's out of office? A majority of the Senate concluded that the answer was yes. So formally, the Senate established that they had jurisdiction and began the trial. But a very large minority thought the answer was no, just like now. And that minority was sufficiently large that when it came time to decide whether to convict, they couldn't get enough votes to convict because the people who thought the trial shouldn't really be happening voted to acquit. So in a way, I mean, ironically, like we are basically repeating exactly what happened the last time we tried this. There's a sort of formal establishment you could have the trial, but then in practice, it was hard to get people to even focus on the merits because it was late. So I suspect, now that we've done this twice, I suspect this will become the precedent. I think that I suspect the precedent will be, yes, technically the Senate can begin trials after somebody's left office, but as a practical matter, it's very unlikely it will come to anything because people can still use the fact that it's a late trial as an argument against conviction. And so we end up having the public proceeding without necessarily any consequences.
Got it. Thanks. So we had a question come in through the chat from a student asking, what is Brandenburg versus Ohio and why do people keep talking about it so much? So I was wondering, this sort of circles back to the legal and high crimes and misdemeanors part of the conversation, but can you give us in a nutshell sort of First Amendment doctrine in 90 seconds or less and why it might be relevant here?
Sure. So Brandenburg versus Ohio is a Supreme Court case about when you can be prosecuted for what's called inciting a crime. This happens a lot during protests. Somebody says something, one day we're going to rise up and take the power back, or they'll be the first against the wall when the revolution comes, or, let's move into the street, or whatever it is. Brandenburg versus Ohio is a Supreme Court test that says you cannot be prosecuted for those kinds of statements unless you are calling people to engage in imminent, like almost right away, lawless action. So if you say to a group of people, let's go, let's attack the police, you can be prosecuted for that. If you say to the same group of people, one day there's going to be a reckoning and blood will run in the streets, you cannot be prosecuted for that because you said one day. And if you say something kind of ambiguous, you can't be prosecuted for that. It's come up in the trial because one of the crux of the things President Trump is being impeached for are his statements to the rally that then raided the Capitol. And so he wants to argue this should be judged under that test. If this is the kind of speech that an ordinary person could not be prosecuted for, I can't be impeached for it. So he wants to kind of make a First Amendment defense to what's happening. And the prosecutors, I think correctly, think that that's not exactly the same standard, that in an impeachment trial, it's not the same question as can you be arrested and criminally prosecuted for this? But that's where it's coming from.
Got it. Thanks. I also think it's probably worth noting that generally, it's been accepted that you can't prosecute a president. So using a Brandenburg test for the president may not be exactly the right standard because you can't actually prove certain things. You can't subject this to the normal criminal process. And so if you said, oh, well, we have to go through the criminal process to find out whether you can, or whether you actually incited violence under Brandenburg, you can't do that with the president because he's immune from prosecution. And so then it's sort of up to the Senate to decide what incitement means and applying the rigid test, like you said earlier, about who interprets the Constitution is a little bit different.
I mean, so there have been a lot of, throughout the various presidential impeachments we've had, one question that has come up a lot, it is a serious question, is, are you only impeachable for things that are basically crimes? Or can you be impeached for things that are not crimes? And this came up during the Andrew Johnson impeachment. It's come up during lots of impeachments. And it's not, I mean, the impeachment does have a criminal flavor. Like it's called high crimes and misdemeanors, we have punishments, it's a trial. Like it takes on a lot of the trappings of the criminal justice system. So it's not crazy to think it's supposed to be about kind of quasi-criminal activity. I think it's not just about criminal activity. I think it is supposed to be about abuse of office. And there are some things that are abuses of your office, even though you can't be locked up for them. And of course, the consequences of this would not be to lock up Mr. Trump, but it's a real argument.
I think Carolyn Freeman has a question. Hey, Caroline.
Hi, Professor. I have a question about limiting principles for trying former officers in the aftermath of a clerkship interview. So in my mind, there's essentially two good options for limiting principles. One is based on the timing of when the House starts its proceeding, and as long as they get it in before the president leaves office, is that okay? Or is it based on when the impeachable conduct occurred? And if we had found out today that Trump did something horrible while he was still in office, would it then be okay to start an impeachment proceeding now, even though he's already out of office? And as a sort of follow-up to that, where does the limiting principle come from? Is it the text? Is it merely pragmatic? Is it from precedents? How do we know?
Yeah. Okay, so I think there are actually three candidates for limiting principles. So the narrowest one, and all that you'd need to satisfy the Trump impeachment, and my former boss, Michael McConnell's written about this in the Washington Post, is as long as the impeachment vote happens while somebody's still in office, the trial can come later. So Trump was president when he was impeached by the House, and then the Senate has the power to try all impeachments. So you could say, putting those two things together, we had a valid impeachment. The Senate has the power to try all impeachments. So once you've got a valid impeachment, you could try it. That would be the narrowest principle. It would rest on the fact that the impeachment got in before the wire. That didn't happen in the 1880 case for Secretary Belknap. So the impeachment vote happened after he left office. Like he missed it by a couple hours. So in Belknap, they argued that the principle is as long as the impeachment inquiry started while you were still in office. So they'd opened a committee and started writing up the articles. It was kind of on the docket. That was good enough. And they borrowed from legal doctrines, very technical legal doctrines about, if you file the first pleading in your case on time, that's good enough, even if later time passes. I don't actually recommend anybody here read them, but there are several hundred pages of debate about this in which they really go into kind of the technical weeds, how they see the limiting doctrine. That's the next option. The third option, which we shouldn't rule out, we haven't needed it here, we shouldn't rule out, is basically that there's no limiting principle as long as it's anybody who committed a high crime and misdemeanor. So if you look carefully at the text of the Constitution, it just says the House has the power to impeach and the Senate has the power to try impeachments. It never says, actually, that the only people who can be impeached are people who hold office. And if you look historically, impeachment came from Parliament in England. And Parliament had the power to impeach anybody who had thought had committed a high crime or misdemeanor. It'd be rare for a private person to be able to commit a high crime misdemeanor, but it's possible. Treason is a high crime misdemeanor, and there are private people who commit treason. So you could go all the way and say, actually, just anybody who commits a high crime or misdemeanor can be impeached. Nothing has ruled that out yet.
Did you want to follow up?
Yeah, just a quick follow-up. How is that not a bill of attainder? Where does that come in?
So I guess two things. So the bill of attainder the idea is the legislature just declares somebody to be guilty without a trial. So one big difference is in an impeachment, we have a trial. The way a bill of attainder would work would be if Congress just announced, both houses of Congress announced without even bothering with the trial in the Senate that the president was guilty and they wanted to punish him in various ways and send him to prison or something. But they're not doing that. They're having a trial. And then so the Constitution contains two principles. It contains this kind of impeachment trial, and then it contains a rule that you can't have a bill of attainder. So when you read those two things together, I think whatever it is that impeachment can do is okay because we have a trial, we have the process. That's part of why we're having the process.
I don't see any other questions right now. If that's my mistake, please let me know. But I guess something that I saw that was interesting was that Senator Cruz was quoted as saying that he believes that it's constitutional to try a former office holder, but that this particular exercise of that power is an abuse of sort of the House's discretion, and therefore he voted against the constitutionality of that. And this is perhaps a little legalist, but to me that's a question for should we convict this person? Not is this proceeding valid in any way, shape, or form? A question of a prosecutor's discretion to bring charges is one that you could raise in like a nullification on the merits, but not something that goes like, is this in general true? And I guess I don't want to ask you to go on the spot as taking a jab at Senator Cruz, but to me that sounds like it's just a very convenient argument to come up with, to say like, oh well, Eric Holder should be impeached, and that would be okay because that's not an abuse of discretion.
Yeah. So I do find it very confusing. I mean, so to defend it, or to be as sympathetic to as possible, to steelman it, I guess. Again, this is kind of like what the precedent has become. It seems to be the precedent has become the Senate will take jurisdiction in a late impeachment, but then individual members of the Senate will decide on their own whether to not convict because it's a late impeachment. So the precedent seems to include both sides, which is just a consequence of how contradictory all this is. So, to Cruz's credit, he didn't make this up. He's kind of getting this from the Senate's own somewhat incoherent practice. I take it the idea is that, the idea of saying we don't have jurisdiction here is to absolve yourself of the need to think about the merits, right? So a senator who says there's no jurisdiction here doesn't want to have to say, oh, the president's behavior was fine or wasn't a high crime or misdemeanor. They want to avoid saying either way. And so they want to refuse to consider the question. I don't totally get how that works, though, because if it's their choice whether to consider the question, then it doesn't seem like it really absolves them of responsibility, right? It's like the Senate has been asked to decide whether Trump has committed a high crime or misdemeanor. I don't want to decide whether Trump has committed a high crime or misdemeanor, and therefore I refuse to consider the question. Just seems like a sort of strange way to relabel the same inquiry. Now, this is something that happens that judges do sometimes too. So, in theory, judges are supposed to have a similar situation where either they have the power to decide the case, in which case they have to decide the case because their job is to resolve disputes, or they can't decide the case, in which case they can't decide the case. And judges in more recent years have started to do something kind of similar, of saying in some set of cases that they have the discretion to decide whether or not they have the power to decide the case. Like at step one, they just they get to decide on their own whether they want to get into it, and something kind of similar to what Senator Cruz is trying to do. Now, I don't think that makes a lot of sense either. Again, I don't see how a judge or a senator can really absolve themselves of their responsibility here either way. But I guess absolution of responsibility is really going around.
I also think that it to some extent ignores the power of the Senate as a fundamentally anti-institutional tool, because the Senate has said we do have this power, and then to say I'm going to persist in my view that despite the Senate as a body voting to continue this proceeding, I'm going to persist in my opinion. It sort of seems like a strange attack on the institution itself. But
this is also a broader question. Sorry, I was just saying, this is also a broader question that comes up for the Senate, for courts. If you're on a group and the group makes a group decision, are you locked into the group, or are there times when you're allowed to say, look, I dissented. I didn't think that was a good group decision, and I'm not going along now. And judges confront this too, and the Senate confronts this, and I don't know that we have a fully worked out way to handle it. Sorry,
JJ.
Hi. Given that senators are probably going to vote based on political considerations rather than legal considerations, and given that currently Democrats do not have the 66 votes needed to impeach Trump, or win the votes necessary in the Senate, what's the point of going through this process? It seems to be quite unlikely that they would be able to succeed, assuming that Republicans continue to vote according to party lines. So is there something else that could be achieved even if they don't get the necessary votes?
I think so, right? And so there's the idealist way to think about this and the realist way to think about it. So the idealist way to think about it is, if you think he's committed high crimes and misdemeanors, you go ahead and bring it forward. And if other people are gonna not do their responsibility, that's not your problem. You don't let them off the hook. You still You still do what you can. So they might just be thinking about it from an idealist point of view, or think it's too soon to tell. Already one senator, one of the Republican senators who was previously against the trial has changed to be in favor of it. So maybe, maybe minds can change. But if you still, I think you're right. I think there are not going to be enough votes to convict Trump. And therefore there will not be enough votes to officially disqualify him from holding future office. But I think there's still a couple reasons to want to hold a trial. So one is just as a public accounting. I mean, as a, much of the point of this trial either way is going to be symbolic, just to sort of put on the record what happened and have a public kind of conversation and vote about whether this crosses the line. And, you still have all of that, even if Trump doesn't lose the legal ability to run for president in 2024, which is the only sort of legal thing that would really be at stake. The fact of the impeachment and what happens at the impeachment might still loom large if he does run later. So it's establishing a kind of public precedent. And then as a purely sort of more political question, most of the Republicans are caught in the following situation. Some of their constituents love President Trump and will get really, really mad if they do anything against Trump. Some of their constituents, or some people who used to be Republicans but have left the Republican Party, feel the opposite way and hate Trump and don't want to be associated with people who defend Trump. So if you're a Republican senator trying to win votes from both of those people, you desperately want to avoid having to talk about any of this. And therefore, if you're a Democrat who wants to make lives difficult for people in the other party, you would really like to force them to take a position. And so part of what's happening is the Republicans in the Senate are being forced to take a position about which side they're on, which will inevitably make some of their constituents upset. But it's probably good for them to have to be explicit about where they stand. Then that's part of why this kind of like technical jurisdictional arguments have been so attractive, I think, to the Republicans, is that seems like maybe it's a way for them to avoid having to take sides. They can avoid talking about whether they think President Trump should be impeached by talking about sort of technical legal claims of jurisdiction. I'm not sure that will have that political effect, but that's kind of the real political thing that's happening here.
I don't know how many voters in Missouri are concerned with William Belknap's trial record or various details like that. But Sophie, did you have a question?
Yeah, I had a quick question. I was just curious if you thought that there were any strong arguments that Trump's lawyers could make to not convict Trump. I've been listening to some podcasts, and some lawyers have said that they think that it would be best to maybe not make a legal argument, but perhaps saying that making an argument about not allowing voters to decide 4 years from now and how undemocratic that is, and just appealing to something that isn't like legal jargon in defense. But I was curious what you thought.
I mean, yeah. So the president's lawyers have a couple. They've not been very good. They have a couple of legal arguments that are plausible, right? One is this sort of argument about jurisdiction. Another is this argument about free speech principles and the First Amendment and whether those should apply. And third is also very technical, is to sort of the way the charges have been drawn really focus a lot on Trump's speech on January 6th and sort of its role in instigating the riot. Seems like there's potential factual uncertainty about the exact role of that speech, the extent to which people had planned the attack beforehand, the timing. So if they, the third thing they can do, which is very much what a lawyer would do, is to sort of say, this exact speech isn't quite what people are saying it is. I think the House could have gotten around that by focusing more broadly on sort of his broader course of conduct from election day to now. But the way things have shaped up, that's kind of a technical way to try to play it. But yeah, because impeachment is not just a technical proceeding, I think there are the broader arguments of, I think Senator Lee tried to put this in a sort of inartful way that like everybody should get a mulligan. But I take it sort of just a broader practical argument is, does anybody still want to be arguing about President Trump? Like, wasn't the point of electing somebody else that we could stop talking about President Trump? So as just a practical matter, I think people could say like, we just want to be done with this. Now, of course, if he were disqualified from running again, then we could be sure we were really done with this. But there is, that's one practical point. And then the last point you mentioned, so I should back up. So in an impeachment trial, there are two questions. One is whether to convict somebody for high crimes and misdemeanors. That's question one. That takes 2/3 of the Senate. If they vote to convict President Trump, they will then ask a second question, which is whether or not he should be forbidden from holding a future office under the United States. And that's one of the main stated purposes of the trial, is to have that second vote so that it can be disqualified from running for president again. So technically, we're not yet voting on that, but you could say, look, we shouldn't vote to convict him because disqualification is a bad idea, and we ought to let the people decide later. If we get to that stage, there is also actually a very tough technical question about whether the Senate can disqualify somebody from running for president. So they can clearly disqualify the president from holding offices like Secretary of War, Secretary of State, all the offices you're appointed towards. But in terms of the various technical language in the Constitution, it's actually ambiguous whether they can say the president can't run for president again, precisely because of the sort of democratic argument you see there, right? It's one thing for the Senate to say this person should never be appointed to anything again. The Senate's in charge of confirming appointments. But for the Senate to say even the American people shouldn't ever be allowed to elect this person again is kind of undemocratic. And maybe the Constitution requires that. It's not crazy, but it's higher stakes.
Great. So I think we are very close to out of time, and I just wanted to say thank you, Professor Baude, and get one last question in under the wire. I want to ask about the road not taken both with this particular issue. You know, some people had said maybe we should just censure the president, and you say a word about like what that means, and what that looks like. And then, you know, Fulton County prosecutors in Georgia have opened a criminal investigation into President Trump's phone call with Brad Raffensperger, the Secretary of State down there. And what that means, you know, I think that some people have said that the president should have been impeached for that phone call in and of itself, but, you know, it was superseded by events, basically, that there was another impeachable offense that occurred, you know, a few days later. And so, you know, in some ways, it seems like we both have too much impeachment and not enough impeachment all at the same time. And how do we think about how to resolve this? Because I think it's important for the country to sort of come to some kind of closure about the, you know, post-election pre-inauguration events, and what, if you were sort of advising all the senators or something like that, would be your advice on how to go forward with this?
Yeah. So the censure is not a sort of explicitly listed in the Constitution, but it's evolved as a kind of like impeachment light. If you don't want to actually remove somebody from office, but you want to symbolically say they've done something really bad, and you want to, you know, sort of register that. The censure vote, really all it is an official statement that you did something wrong with no real legal consequences. So it sometimes gets proposed as a kind of compromise for people who don't want to impeach. I don't know. I think, I guess I'll say, you know, at this point, much of the impeachment trial is symbolic anyway. So I'm not sure that a censure would be that different. And I don't think it's likely that a censure would have proved to be any more bipartisan or any more really would have been that different. So I can see why people decided not to take that road. Criminal prosecution is interesting, and whether or not the president could be criminally prosecuted, especially by a single state, raises both concerns about the separation of powers and federalism that have kind of come up a few times before, but have never been resolved. So we might not be done with constitutional crisis involving President Trump if Georgia decides to pursue that road. But I'll just say the last thing is, I feel a little bit like there's been an institutional shell game for the last several years. So when the president was being investigated by Robert Mueller, and there were possibilities of investigating him for crimes and obstruction of justice, I remember hearing a lot, the president can't be criminally prosecuted, the president shouldn't be criminally prosecuted because the appropriate remedy was impeachment. And then we had an impeachment in which lots of people said, well, you should only be able to be impeached for something that's a crime, which felt a little bit circular, but still, okay, we're going to have an impeachment proceeding. And now we're having a second impeachment proceeding, and people are starting to say, well, we shouldn't have impeachment proceedings because really he should be criminally prosecuted. So I feel like whatever proceeding people are using against the president, people will say you should use some other proceeding. And so it just seems to me like we ought to just sit down and have a reckoning about what we're going to do about the Trump presidency.
Well, thank you so much, Professor, for joining us today. Thank you to the IOP for hosting. Thank you to all of you for joining us. As Christina put in the chat, you can find Professor Baude on Twitter, and you can find more about his academic writing and things like that on his law school webpage. thank you for joining us again, Professor Baude. I would ask that we all give Professor Baude a round of applause for joining us in spite of technical difficulties at home. And thank you all for joining us today. Have a good day.
Thank you all for coming.